that a judgment was entered in this case on the 14th of October 2024 for $12,217.18. Do I have for Gateway Financial, please? Counsel for Gateway.
Yes, good morning, Your Honor. May it please support Scott Schisler, P48832.
All right, thank you, Counsel. Good morning to you, sir. All right, I'm looking for Gregory Palmer now. If you're on this Zoom, please say something, Mr. Palmer.
Yes, I'm here, sir. Your Honor.
All right. Thank you, Mr. Palmer. Good morning to you, sir. I'm looking at your objections to writ of garnishment, and you checked off the box. You said the funds or property are exempt or protected from garnishment by law. Tell me what you mean when you say that.
I'm currently laid off now, and I can't afford to pay as much, but I can pay something a month.
Right, got it. So, yeah, so I can't. That's not a valid objection to the writ of garnishment. So it sounds like what you're asking is for the court to set up some type of payment arrangement for you regarding this matter. Let me hear from Mr. Schisler, and then I'll come back to you. Let's see if we can figure something out here, sir.
Yes, Your Honor. Obviously, if he's not employed anymore, the objection is irrelevant and moot. So
where were you, Mr. Palmer? What
yes,
were you
I
saying?
can prepare that order, Your Honor.
All right, yeah, I've already got an order in that regard. But Mr. Palmer, you said you wanted to set up a payment arrangement in that regard. So what do you want to do? So,
if I could possibly pay like $100 a month.
I'm agreeable to that, Your Honor.
All right. So I will. I'll set up a payment arrangement allowing you to make $100 monthly payments. When would you like that first payment to be due? I'm thinking the 23rd of May. Go as far as maybe the 30th of May. When do you want to make the first payment?
We could do the 23rd.
So I'll set that first payment at 5/23/25. And so your payment would be due on or about the 23rd of each month. First payment being 23rd. I'll deny the objections and I'll suspend moreover any garnishment while you make those payments. If you don't make the payments and if you're working, they'll be able to reinstate any garnishment and continue with garnishment. As long as you make the payment, they can garnish your wages. You understand?
Yes.
All right. So I wish you well. You'll get some paperwork in the mail from me in the next couple of days resolving this matter based upon what has been set forth on the record.
Okay.
Right, good day. Thank you, counsel.
Thank you.
Thank you.
And like some, each 5th day of each month thereafter. And as I explained to defendant, while the case is in recess in the breakout room, I do so now that I ask for defendant's permission to sign his name to a proposed consent judgment so that I can file that order, Your Honor, with the clerk's office at the district court after 3 o'clock this afternoon. With that, I rest.
And thank you, Mr. Rosen. Sir, is this in fact the agreement that you've entered into where you're going to pay the total sum of $12,346.27 with monthly installments at $75, commencing with the first installment on June 5th of 2025? Is that in fact the agreement that you entered into, sir?
Yes, Your Honor.
All right, and given that this is on the record, guys, recorded and I've documented the amounts, is it okay that the plaintiff puts your name on the consent and forward it to the court as long as it has the terms as set forth? That's okay with you, sir?
Yes, Your Honor.
All right, that makes sense. All right, I will convene that the matter has been resolved, and I will anticipate the submission of the consent judgment with defendant's name attached to it as agreed to it, given that there is a record of the same, and you may proceed in that manner. All right, good day to both parties.
Thank you, Judge. I rest.
Everything. Have a nice day. Thank you.
Nice day to you, sir.
36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Colby presiding. While court is in session, there'll be no eating, sleeping, talking, gum chewing, or reading any material. Thank you.
All right, this is case number 24. 167299. This is LBMB Funding LLC versus Samuel Campbell. The matter is before the court set on for hearing on a motion for summary disposition. The matter is set for a pretrial conference at the same time. Your appearance for LBMB Funding, please.
Najat Francis on behalf of Plaintiff's Attorney of Record.
All right, go ahead and put your P number on, Ms. Francis.
Oh, I'm sorry, P72322.
All right, thank you, Councilman. Good morning to you. I'm looking now for Samuel Campbell. Mr. Campbell, if you're on this.
Your Honor, opposing counsel has given us permission to sign a consent judgment, and we will submit that consent judgment to the court, Your Honor.
All right, I will note to the file that the matter has been resolved. The court stands in anticipation of a consent judgment disposing of this matter. All right, thank you, counsel.
Thank you, Judge.
All right, the court now calls case number 23-24-0571. This is Kim Rogers versus Elmore Green. The matter is before the court on the court setting the matter on regarding a motion that was filed with the court. All right, your appearance, excuse me, do I have any attorney involved on either side of this? If there's an attorney, the attorney speaks first. All right, Kim Rogers, do I have Kim Rogers on this Zoom? Kim Rogers? All right, do I have Elmore Green on this Zoom?
Yes, you do. Elmore Green is here.
All right, thank you, Mr. Green, and good morning to you, sir. You filed a motion for satisfaction of judgment in this matter. Why do you believe that this judgment should be satisfied, sir? Talk to me.
Me and Ms. Rogers worked out. I was buying a home and they wanted me to make sure they wanted to get a clearance that I got this judgment off my record before I could buy this home. They didn't know if it would affect the loan that I was getting or not. So we never got a final paperwork saying that it was done and the debt was paid off.
All right, and the record should reflect that the court received a call from one Kim Rogers notifying the court that the judgment in this matter should in fact be satisfied. So there is an indication that there's no opposition to the satisfaction of the judgment. The court will accordingly grant the motion at this time to satisfy the judgment. Now, you did offer me a proposed satisfaction of judgment form, but lucky for you, I have one. So
Thank you. Thank you. Thank you.
I'll put a sign there. You'll get it in the mail in the next couple of days. All right. Good day to you, sir.
All right. Thank you again. Thank you, Your Honor.
So you know which form I need on that, right?
Yes, that's right.
All right. The court now calls case number 24-16847. This is Credit Acceptance Corporation versus Mustafa Masluki. Matter is before the court, settled for status conference. This is the first hearing regarding this matter. Your appearance for the plaintiff in this matter, please.
Thank you, Judge. May it please court, I'm Attorney Richard Rusin, my bar number 35222.
All right, thank you, counsel. Good morning to you, sir. I'm looking now for Mr. Mustafa. I'm sure I'm getting the last name wrong. If you're on the Zoom, go ahead and say good morning.
Good morning, Mr. Judge.
Thank you, sir. And how is that last name pronounced, if you will?
It's Masluki.
All right, Masluki. Thank you, Mr. Masluki. Again, good morning to you, sir. Mr. Rusin, go ahead and update me. I know the letter that I received that I treated as an answer for purposes of setting this hearing indicates a denial of the indebtedness. Sir, any updates at this time?
Judge, I can tell you, I'm sorry, Richard Rusin for the record, my bar number 35222.
All right, the court now calls case number 24-144-583. This is Midland Credit Management Incorporated versus Marcia Kimball. The matter is before the court set on for hearing on a motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Viola Osco on behalf of Midland Credit Management, P number 84802.
All right, thank you, counsel. Good to see you again. I'm looking now for Marcia Kimball. Ms. Kimball, if you're on this Zoom, please say something at this time. Doesn't seem that she's here, but I see a note that I had that was regarding a conditional dismissal. But again, counsel, tell me where things are regarding this matter.
All right. Well, there was originally a motion for summary disposition scheduled earlier this year on January 7th. We reached an agreement and we exchanged some settlement paperwork after this hearing, but the defendant's attorney has not been responsive, and I would like to pursue this motion for summary disposition if possible.
Right, thank you. And I don't see opposing counsel. I know that there is a Gerard Scanlon who has an appearance regarding this matter. Let me ask you, counsel, did you receive any response to the motion for summary disposition?
No, I did not. We did receive notice for this hearing for today and this time, though. And it was, I see defendant's counsel's address here. So
Yeah, I do see where there was a response, defendant's brief in support of, well, defendant's response to the motion for summary disposition. That was back in January. I know that this was originally set in front of Judge Robinson, and then I took over this matter. So have you had any contact with the defendant's counsel here recently? I know you said that there was some thought that it was resolved, but they never, you have not been able to reach them, or they've not been responding?
no, I emailed counselor on Friday and I did not receive a response. Also, my colleague and a paralegal tried to reach out to him since the motion on January 7th, and it has not been returned to us.
Very well.
I'm on the Zoom real quick.
All right, so given that the so counsel, you represent Midland, correct?
Correct.
Given that the defendant has not responded to appear in court for hearing on this matter as directed by the court's order of March 18, 2025 and April 9, 2025. In both instances, the court has directed that the defendant appear for a hearing on the motion for summary disposition. The defendant does not appear and therefore has abandoned any arguments as it relates to the motion for summary disposition. Accordingly, the motion will be granted at this time, and judgment will be entered on the granting of the motion. So ordered.
All right. Thank you, Your Honor. Will the court be entering the judgment that was originally filed with our motion for summary disposition?
Well, you certainly anticipated that I would be looking through here to see if there's an order attached to your motion. So just give me a moment. And I do see that now. And so the court will be entering that order at this time. Thank you.
All right. Thank you.
All right, this is case number 23-163-486. This is Advanced Pain Care PLLC. This is Ashley Jeanette Blackshear. Matters before the court. Looks like an adjourned date of hearing regarding objections to a writ of garnishment. Your appearance for Advanced Pain, please.
Timothy Frost on behalf of plaintiff, Your Honor.
All right, Mr. Frost, go ahead and put your P number on the record, if you will, sir.
40616.
All right, thank you, Councilman. Good morning to you. I'm looking for Ashley Blackshear. If you're on the Zoom, please say something at this time. Blackshear. All right, Council, Mr. Frost, update me with what you know about this matter, sir.
Defendant has failed to appear for her own objections. Your Honor, we filed a response stating she may not use the objections to challenge the underlying judgment, which is occurring here. And even if the court were to construe the objections as a motion challenging the judgment, it was not filed within 1 year, so it's untimely. And those are our first two responses. And based on that, we ask that the objections be denied at this time.
Thank you, Counsel. The sense of my inquiry was whether or not there had been any intervening contact with the defendant, given that, of course, she's not here. So since the filing of this motion, you've not had any contact. She's not reached out to you or anything along those lines, correct, Counsel?
That is correct, Your Honor.
All right, thank you, Counsel. It does appear that the defendant has not appeared, although a notice did go out on the 9th of April, setting this date as the date of hearing. The defendant has failed to appear on the motion, petition objecting to the writ of garnishment. It did appear, moreover, that the objection sounded in issues that were pre-judgment rather than post-judgment matters, which would be prohibited under the appropriate applicable court rules. Accordingly, the objections will be denied for all of the foregoing reasons. All right, thank you, Counsel. Good day.
Have you signed, Judge? We have a proposed order attached to our response there.
Well, I don't have your response. I don't have the proposed order. I don't have a file this morning on this particular matter. So something did not populate, or the file got misplaced or something. So I'm sure that will be resolved. But all I have is a basic skim file because we okay the original. Doesn't mean that we don't have it. So that's the only reason I don't have your order. I will sign an order consistent with this matter. And the first thing I'm going to do is to see if we can get our hands on the file to sign the order that you submitted. If not, I will issue an order nonetheless.
Very good. Thank you so much, Your Honor.
All right. Thank you. Thank you, Mr. Frost. Good day.
You too. Thank you.
To Judge, I can tell you that while the case is in recess, with the parties being in the breakout room, that the parties have agreed to enter into a consent judgment. The consent judgment will enter in the amount of the complaint, which was $11,985.19. That's 11985.19. I explained to defendant that there were what the law calls taxable costs, which consisted of a $160 summons filing fee, $106.08 summons service fee, and a $20 motion fee to facilitate the service of the summons. The total taxable cost, Your Honor, are in the amount of $286.08. That's 286.08. I explained to defendant that there is a statutory $75 attorney fee in this matter, concurrent with the entry of a consent judgment of this type. The total consent judgment will enter, Your Honor, in the amount of $12,346.27. That's 12346.27. More importantly, Your Honor, the consent judgment will concurrently have an installment payment enter in the amount of $75 monthly, beginning June 5, 2025, and then